Mode.
Happy Halloween, everybody. Here we are with the exciting webinar to hopefully scare you just a little bit on Halloween. I'm here in California with David Kaminski out in the Midwest. We've got Tom Moore with Avtex. David Kaminski is with Carlson and Meltzer, and we're going to talk about the spooky TCPA laws and what you can do to protect your company coming up in the fall and into next year, and what consent really is all about. So I'm going to turn it over to Tom. I'm with Ryan Thurman. I'm with Contact Center Compliance, DNC.com. A lot of you may not recognize me with my Where's Waldo costume. We're having a little party here today. So hopefully we're going to keep this to about an hour and a half. We've got time for some questions at the end. We're going to do question and answer as we go through this. There should be a tab on GoToMeeting that you can fill out to ask questions, and I think we'll have some time at the end. We do have a lot of information that David has compiled, as usual, and this is kind of part 2 of our post-TCPA coverage. Now the law is in effect, a lot of impacts to the industry. Our volume has gone up in terms of cell phone scrubbing. There's lots of confusion and questions about what you need to have on your disclosures, etc. And so without holding up the train too much, I'm going to turn it over to Tom. He's going to say a few words, and then David will give us the bulk of the presentation. Thank you.
Thanks, Ryan. Again, this is Tom Moore with Avtex. A pleasure to be here again, and looking forward to this webinar. Avtex is a company that is focused on using our technology know-how to enable our clients to deliver an exceptional experience to their customers. We also work with companies to help them stay compliant within their contact center environments. So again, it's a pleasure to be here, and David, take it away. Looking forward to it.
Hello, everyone, and thank you so much for attending this seminar on Halloween. I guess I couldn't envision anything more scary than all of you having to listen to me for an hour and a half, but we're going to give you all of the law. We're going to go through it in detail, and then we're going to have plenty of time for your questions, and I want to answer your questions because I know you're going to have a lot of them. So with that, Ryan, let's advance the screens and take it away. Well, Ryan, I can't see the PowerPoint, so forgive me, everybody.
You should have the TCPA Act. I just skipped ahead to the initial slide with the TCPA Act of 1991 with the first bullet there.
Yeah, I didn't see it advance on my screen, Ryan.
Oh, you know what? For some reason.
Now, there it goes.
Sorry, I clicked I clicked the wrong button.
Halloween glitch there. So, and keep on advancing, Ryan. You'll see it populate. Everyone, you know about the law. You know that the TCPA was enacted in 1991. You know that it was not envisioned to transcend to every industry that's using a dialer, but that's what's been happening because the TCPA is so broadly worded and no industry is excluded in the language of the TCPA itself, which you're going to see in a second. All of the industries, I'm talking about the collection industry, the banking industry, the healthcare industry, any industry that uses a dialer, they are falling into the purview of the TCPA solely by virtue of this technology. And that's what's happening. Next. So let's just talk about the law here, right? I know many of you know it, but we're going to really make the distinction because it's important today between cell phones and landlines. This section here that you're looking at is the cell phone ban, what we call the wireless auto dialer ban. And basically it states this. You're prohibited from using an automatic telephone dialing system, and we're going to get into later what that is, from calling basically a cell phone or leaving a pre-recorded message on a cell phone without prior express consent of the called party. Again, it's a call to a cell phone made with an automatic telephone dialing system or a pre-recorded message without prior express consent. So that's very important. And then we're going to get into some other issues. Next, and Ryan, my webinar seemed to close again. But anyway, next, let's talk about, is there a charge to a call needed? No, you don't basically have to have a charge. Next, Ryan, so you can populate it. Yes, there we go. You don't have to have a charge to a call to have standing to sue. Remember, the wireless ban prohibits a call to a cell phone via an automatic telephone dialing system or a pre-recorded message without prior express consent. What we're also going to get into is this fact. Under that wireless ban, there is one little provision that I know you know about from a case that came out recently. And in this wireless provision, they have a little caveat that says not only can you call a wireless phone, but any service for which the called party is charged for the call. Again, any service for which the called party is charged for the call. Well, what does that mean? What kind of service is that? What are these other services that maybe we can't even scrub for with cell phone identification that someone may be charged for a call? I'm never going to even know that, and all of a sudden I'm going to have potential TCPA liability. That doesn't make sense, and we're going to talk about that in just a little bit. Remember, calls for emergency purposes don't constitute calls that fall into this dialer restriction. But just remember this, that many of my clients who are banks, collection agencies, et cetera, they say, well, it is an emergency for us to collect our debt. Well, unfortunately, that is not the type of emergency that we were talking about here. Next. So let's talk about the landline restrictions. Remember, there's two prongs to the TCPA. You got the cell phone, you got the landline. On the landline side, this is what it says. There's a prohibition for initiating a telephone call to a residential line by a pre-recorded message. It is not making a call via an automatic telephone dialing system to a residential line. You can use your auto dialers all day to call residential telephone lines, but it's when you leave a pre-recorded message, that's the potential trigger for liability on the landline side. Big difference. On the cell phone side, you've got potential liability for calling via your automatic telephone dialing systems and leaving a pre-recorded message. That's on the cell phone side. But on the landline side, it's only leaving a pre-recorded message. Next. Let's talk now about call forwarding. And leave it right there, Ryan. Oh, well, we populated it. Basically, I think all you know, when debtors, consumers, they forward their calls, they're from their residential lines, if they even have them anymore, to their cell phone, that doesn't create a claim. In other words, if you're using your dialer to make a call to a residential line, you're not leaving a pre-recorded message, and someone has forwarded their their landline call to a cell phone. That doesn't create a TCPA claim. Next, monetary damages. Look, the damages under the TCPA, and you can see the little man on the right, yes, there's a reason why he's smiling with the money, because this is what is happening to the plaintiff's bar here. They are seeing the TCPA as an actual, it's just a ka-ching. It is a cash register. There's $500 per call. There's $1,500 or 3 times 500 for a willful violation. And that doesn't seem so bad in the abstract, but when you add that up, when you're talking about potential class action where maybe you have potential let's say class members of anywhere from 10,000 to a couple million, those numbers become extraordinary. I was defending a client recently in a TCPA class action, and I talked to the judge. I said, Your Honor, for this 30-person company, only 30 people in the entire company, small little company, their potential liability under this statute based upon the calls made over a 4-year statute of limitations period, because that's the statute that applies to most of the states and the federal courts who are doing TCPA claims. It was $4 billion, and the judge looked at me, $4 billion? I said, yes, $4 billion is the potential outside liability. And I said, Judge, that exceeds the Chrysler bailout by the U.S. government. She said, we have a problem here. And she did say that. Of course, she didn't know what to do with it, but that shows the absurdity of this. Willful violations, many courts are finding willful. It's not that hard of a stretch, but if the company, let's say, is calling someone and someone says, do not call me on this telephone, it's not my phone, I don't know you, I have no business connection with you. If you continue to call, I've seen some courts have come down and said, well, that could be potential willful conduct because you already know that you're calling someone with who you have no business connection and you continue to do so. There are other facts, of course, which give rise to a potential willful claim. Again, the TCPA doesn't provide for recovery of attorney's fees. And I have there a caveat about TCPA class actions. In TCPA class actions, people can backdoor attorney's fees through something called the Attorney General or a common fund theory. And I've rarely seen a case where a plaintiff's counsel was successful in either certifying a class and prevailing or settling a class action and not obtaining attorney's fees. Remember, under the TCPA, the good thing is manually dialed calls, and we're going to talk about what that means later. A pure manually dialed call, I pick up my VIA telephone that's on my desk and I dial 10 digits. That does not violate the TCPA. Next. The established business relationship exemption. The FCC has done this. Congress gave FCC the authority to make rules and regulations to implement and explain the TCPA, and they most certainly have. They have hundreds of regulations. Some of them literally mirror the TCPA statute, but some go further. Some are related only to telemarketing, and they're specific as to the telemarketing industry. So there is this exemption for pre-recorded calls to residents under the established business relationship exemption. Well, unfortunately, the FCC has said as to telemarketers that as of 10/16/2013, they have to literally, quote, cease utilization of the established business relationship exemption. So if you had one of these relationships, and courts never know even how to understand what an EBR is because it's confusing, they're saying that, unfortunately, telemarketers, you have to cease using this as of 10/16. So as of roughly 2 weeks ago in a day, they can no longer use the EBR as a basis to have prior express consent. Just remember, the exemptions that I'm going to be talking about here today only apply to pre-recorded message calls to landlines. Okay, again, the exemptions that the FCC has implemented are only relate to pre-recorded message calls to landlines. There are no exemptions for pre-recorded message calls or auto dialer calls to wireless lines. So on the wireless line side, there just aren't exemptions. The FCC didn't feel a need to do that. Yes, huge mistake, but nevertheless, that's what we're stuck with right now. So the question is, of course, if telemarketers have to cease utilization of this EBR relationship, does that apply to every other industry? It's not clear, but can the debt collection industry still rely upon it? Again, not clear, perhaps because only telemarketers have to cease utilization. They weren't saying that they were striking the actual EBR provision, so maybe a debt collector has still an established business relationship, but it's very difficult to establish. It is very confusing. Even courts who have interpreted the EBR said, I really don't get this. So when Ryan goes to the next slide, we're going to show you why, because there is another exemption that does help. So an exemption that favors debt collection industry and is called the commercial call exemption. So the commercial call exemption is basically a call that does not transmit an advertisement. It's not a solicitation. It's nothing other than transmitting information, similar to an informational call. And basically the FCC realized that debt collection calls were basically business calls. So they gave a categorical next exemption. And that categorical exemption, as you'll see just populated, basically says this. Look, the FCC is saying you're making a call that you have a relationship with something. It doesn't transmit an unsolicited advertisement, and it's basically a call for a commercial purpose. That is a call that we're going to say does not constitute a call that violates the TCPA for making a call to a pre-recorded message call to a residential line. Again, the commercial call exemption, which you're seeing there in 64.1200.823, is only an exemption that helps the debt collection industry with regard to pre-recorded message calls. And the FCC thought that this exemption was very, very broad. And they're making it, and I use the word categorical because it pertains to these categories of calls, pre-recorded message calls made to a landline. Very, very good exemption. Next. Basically, next, you're going to see that courts have interpreted the exemption fairly broadly. Look, there's the Meadows decision. Next, the Meadows decision is the Meadows decision is a very good decision. That decision says, look, this exemption, the commercial call exemption, is basically so broad that it covers almost any debt collection circumstance. Look at the cases below. Hoover, which cites also to Fernasiak. Why these are great cases is for this reason. These courts have interpreted this FCC exemption for commercial calls as being so broad. They're saying, look, even where you're making wrong number calls to a debtor, and even where the debtor says, stop calling me, that exemption is so broad we even think it covers those calls. Now, some courts may disagree, and some courts may say, look, you've made X amount of calls to this person after they told you they're not the correct person. So if you're making pre-recorded message calls to a landline after a person has told you not to, some courts may see that as an invasion of privacy, but the way these courts are interpreting the FCC exemption, they said, hey, it's so broad that, sorry, it covers even wrong number calls, even where someone told you to stop leaving pre-recorded messages for me because I am not that right person. That's how broad these courts think the exemption is. Next. Let's talk about something that I know is concerning all of you. Let's talk about, next, this Lynn case, which talked about VoIP phones. So we know that there's scrubbing technology out there, cell phone identification technology. With that technology, you can determine what is a landline. You can determine what is a cell phone, right? But not every technology can, quote, determine whether someone is using a VoIP phone. This is what this court said. The plaintiff said, hey, I'm using this VoIP phone, and that I think is, and I was charged for my call. So guess what? I think this falls under the B1A prong of the TCPA. That's the B1A prong, see below, versus the B1B. The B1B is residential. The B1A is the cell phone or wireless. This plaintiff argued, this is a B1A claim because guess what my service is? It's not a wireless line, but it is any service for which the called party is charged for the call. So because of that, I think this falls into the wireless prong, and therefore it's more akin to a cell phone call. The court actually agreed with the plaintiff. The analysis was thin. The argument was that, look, this is a VoIP phone. It ultimately emanates from a residential line. I don't care what kind of technology comes in, but it comes through some kind of wired line or something coming through the home. That is a VoIP phone as opposed to something that's wireless. Wireless is supposed to be in the B1A bucket. This court unfortunately disagreed with that and put this in the wireless line. I think that the decision was wrong. I understand that, look, even if you could do a scrub for cell phones and residential lines, that doesn't mean you can always determine whether something is a VoIP phone. Sometimes you can do a reverse lookup and it will identify whether, let's say, the number that you're calling is attached to a VoIP equipment, but you're not going to know that. It's not foolproof. It's not clean. It's not like the scrubbing technologies that clearly can identify cell phones versus residential lines. So this is a problem in the law. I think it's a conundrum. I think this decision was decided wrongly. I hope that other courts do not pick up this decision and run with it. The case was settled, but there's going to be a possible appeal on some of the issues in here, and we suspect, of course, it's going to be where the judge put this particular VoIP phone into the cell phone bucket as opposed to the residential line. Next. I know that you also are very concerned about some cases that you heard about. Look, you heard about these exemptions that were applied recently by one judge in Philadelphia, and he said that, look, the FCC has determined that debt collection is so broad that basically any debt collection call is excluded from the TCPA, and he meant calls to cell phones or wireless lines, and calls to wired lines or residential lines. And in this, the court cites the Meadows case, and I'm looking at Roy versus Dell right now. So in Roy versus Dell, the plaintiff said, hey, I was called on the system, and this is a call under the cell phone prong. The court's analysis was very, very thin. He didn't even distinguish whether the call was made to a cell phone line or a residential line. He just said, well, it doesn't matter what it was made to, basically, because every debt collection call is excluded from the TCPA. Doesn't matter. You're going to see other decisions that we're going to show you later from Pennsylvania. The Pennsylvania federal district courts, God bless them, they hate the TCPA, and with good reason, because it's out of control. Unfortunately, some of the decisions that they have made have gone, let's say, a little, I think, over the top, and if those decisions get appealed and if an appellate ruling comes out, sometimes that could be worse for the industry. So that's the problem. Yes, we love the defense-oriented nature of these decisions, but are they going to hold water is the issue. So here, this court says, hey, look, every debt collection call is excluded from the TCPA. Doesn't matter if you're calling a wireless line or a wired line, a residential line. Well, they're citing the Meadows case. The Meadows case was clearly a residential line call case. The case above, Rafala, in that case the judge was vague about the TCPA exemption, but in that case it was very clear and defendant established that they were calling plaintiff's landline, and the judge's decision was correct to exclude pre-recorded message calls from the purview of a landline call. But in Roy, the argument is this. Well, wait a second. What is there in the TCPA that says that the debt collection industry is excluded? The FCC said that in connection with residential pre-recorded messages, but that's about it. This court construed it a lot broader. Someone else made the argument recently in the case that you see there in Ningas, but the court in that decision said, look, there is nothing, if you read the plain language of the TCPA, that excludes the debt collection or any other industry for that fact. The language doesn't have that. So in a pure reading of the TCPA, it doesn't say it, so debt collection therefore falls within the purview. And I believe that most jurisdictions throughout the United States believe that the residential call exemptions do not apply to the wireless line calls or calls to cell phones. Next. I know everybody was very hopeful about this case, but I think on appeal it will be potentially problematic. Next. All of you have heard about the Soppet case. You're hearing about who has standing to bring lawsuits when they're called on their cell phone. Next, unfortunately, Soppet, this is what happened in short. There was a call to a person for whom the debt collector had prior express consent. They got the number with consent. But unfortunately, that telephone number was reassigned to someone else. So someone else now has the number that the debtor had for which the debtor gave consent to the collector to call. So the collector calls the third party and said, hey, I don't have any relationship with you. You're calling me on my cell phone, and you shouldn't be. This court is saying that if that cell phone person is a subscriber, then they are any called party, as that language is used in the TCPA, and they have the right to bring a lawsuit, even though you didn't intend to call them. We are not going to restrict standing or the right to sue only to, quote, intended recipients, meaning those persons who you intended to call. TCPA was worded very broadly. It said the called party has the right to bring suit. This court said, the Seventh Circuit said that that is the subscriber. Next, you're going to see another decision called Levy, which follows the Soppet ruling. Next, and let's advance again. Next. Interesting, another decision that's important. I think you went too far, Ryan. Let's go one back. The Breslow decision. No, let's go next. Oh, I'm sorry. There seems to be something out of order. Let's go next. One more, Ryan. So there's a decision called Breslow. Just mark this down, B-R-E-S-L-O-W. Breslow is versus Wells Fargo Bank. And that case is on appeal to the 11th Circuit. Same issues as Soppet. And of course, the defense is arguing that only the intended recipient should have standing, not the person who was actually called, because there is basically very limited ways in which we can determine if we are calling a wrong number recipient. That's the problem. If you get prior express consent in the first place, so you have the right to call someone, is there technology out there that can help you, quote, identify if the person you're calling is still that person that gave you consent in the first place? There are some companies that do offer services. Who knows if they're 100% accurate, but they are out there, and they can certainly help you to examine this. But before these companies had this service, there was no way to tell. So listen, 2-3 years ago, if let's say someone brings a class action, let's say a 4-year statute of limitations applies. Well, look, 2 years ago, 3 years ago, there wasn't any technology even a year ago to tell whether the number that you were calling pertained to the person that gave you the consent in the first place, or was that number reassigned to someone else. So you're going to see some courts here like Mono, they're saying that the regular user of the phone has standing. You're going to see Chelco there, and next, Ryan, Chelco, that case is the subscriber and the regular user, they have standing to sue. So what's going to be done about this? I mean, it's very difficult. You never know if you're calling a wrong number, and I get that. Someone gives you consent. You have that consent until they vitiate or take that consent away from you or revoke that consent. You should be able to call that number. Well, unfortunately, with a lot of the cases that we're seeing and the way the country seems to be going, and what I mean by that is the way the courts throughout the United States seem to be interpreting the word called party under the TCPA. They're interpreting it very broadly, and unfortunately, they're saying, hey, look, if the person you called, wrong number call recipient, they had no business relationship with you, they had no consent with you, and they didn't give you the number, and you're calling them, and it's their cell phone number, and if they're subscriber and or the regular user of the phone, they have the right to bring a TCPA suit. Some of these people are even bringing these suits on a class action basis. So I know it sounds insane, from one wrong number call, which you maybe couldn't have defended yourself against because the call was, let's say, made 2 years ago before any technology existed to identify who was the current subscriber of the phone. And even, by the way, if you identify who the subscriber is, that may not tell you who's the regular user of the phone. Let's say a father and a family, he is a subscriber to the cell phone plan for the family, and you've got adult children who are regular users of the cell phones within that plan. You're not going to be able to see that from a particular service that, let's say, gives you the ability at least to determine who is the subscriber. But I guess if that service, of course, can identify that the person you're calling isn't a subscriber, that at least is going to maybe give you a clue that you may not have consent to call that number, even though you had it at one time. Let's talk about the safe harbor. Is a safe harbor available? And what I mean is a safe harbor, is there going to be an exception or an exemption? We have been speaking directly with the FCC, and I have spoken directly with them in meetings. And I said, look, this is insane. There's liability now for wrong number calls, and they actually got it, and they were sensitive and somewhat sympathetic to this issue. So we believe that a petition to the FCC will be coming out shortly, will address this issue, and we're hoping that the FCC will give us for some relief, say that there is no, let's say, potential liability for a wrong number call as long as you had the cell phone number with consent in the first place, and you can demonstrate and prove that, let's say, until someone tells you that you're calling the wrong person or that this isn't their number. And so we don't know how it's going to look exactly yet, but we're working with the FCC in this regard, and we're hoping for some relief. I know my clients who I'm involved with in countless TCPA class actions right now realize that this is a huge problem. Next.
Hey, David, just real quickly to add to some of the questions we've gotten. Yes, we are recording this, so we'll have it available where people can replay this if they missed anything. We'll also be getting a link out for people to get the slides later today, tomorrow, so they can, you don't have to write everything down. But also wanted to, David, let everybody know that just so that they can not have to feel like they write anything down. So we didn't really mention that at the beginning. So we'll let you continue.
Thank you very much. So next, let's talk about the mothership, prior express consent. I know it keeps on changing so much, no one knows anymore what is prior express consent. Next, and populate the whole screen. So look, as you all know, the FCC was years ago somewhat sympathetic to the plight of the collection industry, and with regard to a petition that was made to them saying, hey, look, you got to help us here with the TCPA, exempt the collection industry from the TCPA. Well, the FCC, in its traditional manner, said, no, that is not happening. But what they did is say, look, we're going to give you this gift, collection industry, and we're going to say this. If you're calling a debtor on behalf of a creditor, and if that creditor obtained the cell phone number with prior express consent, either orally or in writing, in documentation, then we're going to say, you, debt collector, calling on behalf of that creditor, you stand in the shoes of that creditor, and you, debt collector, by virtue of collecting on their behalf, have prior express consent. So again, where debt collector calls on a debt on behalf of a creditor, the creditor got prior express consent, FCC is saying you, third-party collector, have prior express consent yourself, even though you did not get it directly. And in this regard, how can consent be obtained by that creditor? Can it obtained orally or written? Absolutely. The new written prior express consent rules, we're going to get that into that later. Can consent be provided to the creditor? Well, it has to be. If we're talking about this pass-through consent, where you, debt collectors, let's say, get it by virtue of the fact that your creditor had it, that's pass-through consent. And yes, in that regard, the creditor has to have it. Someone has to have consent. Absolutely. Can a debt collector get consent directly from the horse's mouth, the consumer, the debtor at issue? Of course. Next. But this is the gift, and in fact, it's during a recent speech that the FCC gave, they called this the gift to the debt collection industry. So this is where it gets a little tricky. So when is this consent? What's the timing of this consent? When do you have to have it in order for it to be real and existent? Well, in paragraph 10, this FCC says it's only provided if given to the creditor during the transaction that resulted in the debt owed. During the transaction that resulted in the debt owed. Well, what does that mean? Does that mean at origination? Does that mean at the time someone executed the credit card agreement, the loan application, the mortgage application, and signed their name on that application? Is that at origination? What happens if you have a revolving account? What does that mean? Well, the FCC also says in the same exact February 2008 ruling that consent is proper if the number was given in connection with an existing debt. So in connection with, and they say this not only once but roughly 3 times in that same FCC ruling. I believe it's in paragraph 1 and in paragraph 9. So they use this word in connection with. So they sort of contradict themselves in their own ruling, which, let me tell you, is not unbeknownst to the FCC. They've done that hundreds of times. And that's the problem. You'll see the decision at the bottom, the Meyer case. The Meyer case says this: hey, look, we saw what the FCC said, and we see where they say during the transaction, but they also use the word in connection. So we deem that what the FCC means is that, look, as long as you get a number in connection with a debt, and you get that number voluntarily with the express consent of the consumer or the debtor before you place an auto-dialed call to a cell phone, next, you've got consent. That's not what every jurisdiction says. To be honest with you, just remember this. Some jurisdictions are interpreting that paragraph 10 literally. They're focusing on that, and they say, well, that's what the FCC said, and we can't challenge it. They're saying during the transaction that gave rise to the debt, and sorry, if you didn't give your number then, well, then it's not express consent, even if the debtor or consumer gave it voluntarily later. That does not make much sense, does it? But some courts will take a strict construction of that FCC paragraph 10. What courts need to be made aware of is that the FCC itself said is in connection with is fine, and the Ninth Circuit decision interpreting that certainly helps. Let's talk about what consent is and how you get it. So can it be verbal and writing? Yes, we've talked about that. TCPA never said what kind of consent you have to have. Yes, they did in their February 15, 2012 report, but that's probably limited only to the telemarketing industry. And if you're telemarketing or selling goods or services and advertising. If it's a pure commercial call, no. Or informational call, no. Okay, another case, you'll see the green case right there, where the debtor gives their, let's say, their cell phone number voluntarily to the credit bureau saying, I want to be called before anyone gives me credit. If a creditor potentially calls them because they saw that on the credit bureau, well, that's express consent because the person's telling the world, call me. Look, via website, sure, you have a website application, someone checks the box, they voluntarily provide their number, that's consent. Next case, placing number on an educational loan, that's on an application. That is deemed voluntarily consent. In fact, the FCC really, really likes that. The FCC sort of, you'll see later, even suggests that creditors, companies, banks, credit card agreements that they put into the terms and the conditions that someone has to sign that they may be called via automated telephone dialing equipment or leaving pre-recorded messages. So when they put it on an application, you're good to go. Remember that this consent has got to be provided by the consumer, not by a relative, not by a friend. I know people say, well, can we get it from a spouse? It really should come from the horse's mouth, from the consumer themselves, because that's what express consent is, from the person. So in the spouse situation, let's talk about that. Does the spouse have authority or control over, let's say, the husband or the wife's cell phone such that they can give consent? Maybe, but maybe not. But doing it and obtaining it that way is a risk, and you may be buying yourself a lawsuit only to prove that you were right or to prove that you were wrong. It's not worth it. Only get consent and only take the phone number. So let's say you're calling a landline. Let's say you're calling what you believe is a debtor's home, and it is. And let's say the debtor's mother answers and she says, oh gosh, Tom is not here right now, but let me give you his cell phone. Is that express consent? Likely not, because you're going to invite a lawsuit to prove that you did or did not have consent through the mother. Next, let's talk about what is not express consent. Pretty clear. You get a number and you capture it through caller ID or those devices. That is not consent unless someone has previously given you consent to call that number in the first place. When someone tells you, hey, don't call me on my cell phone, whether that's verbal, in writing, please honor that. We're going to show in a minute, and we could just talk about it right now, the Gager Third Circuit appellate decision. That court said, look, someone tells you orally that they don't want you calling them, honor that request. Oral revocation is proper under the TCPA, and I believe most jurisdictions believe that to be true under the TCPA and will likely hold that way. If you have consent that's provided to one creditor, right, you're saying, hi, can we call you on this GE account? Someone says, yes, you have authority to call me on this phone. Well, that's consent right there. Do we have permission to call you on this phone, on your cell phone with respect to this account? Yes, you do. Well, does that mean that you can call them in any and all accounts that they may have for you? Probably not. But if you've gotten consent in this manner, do we have permission to call you for any and all accounts that we may have now or in the future? If the debtor or consumer says, yes, you do use this phone number at any time that you're ever going to call me for any purpose whatsoever, and if you get that fantastic language, well, that's wonderful. And that's probably very broad language to capture consent, okay? Skip tracing. Skip tracing, Meyer portfolio, Ninth Circuit decision. They say, look, if you skip trace, you don't have consent because you never know, did the person give you the number in the first place? Well, if you skip trace a number, we know that skip tracing is very near and dear to the collection industry's heart. You need to get information. You want to look for third-party information or through third-party sources to get information in order to call consumers. But if you load those into your dialers without knowing if you have consent, potential problem, and in this case, Meyer gave rise to a TCPA class action. Next. If you do skip trace, don't load the number into your dialer till you know you have consent to call that. Next. I know this decision is plaguing everybody because it went viral once it came out. This is the Mays decision. And this is the decision which is up on appeal right now to the 11th Circuit. There's going to be 4 issues that are going on appeal, and I'm going to break them down for you. This is what happened in Mays. In short, I believe the A couple that come into the hospital. It was the husband. He goes into, I guess, emergency treatment. The wife puts his cell phone number down on the hospital admission application. I believe that the husband got some radiology treatment, and then later on the radiologist had a debt that the husband didn't pay, and therefore hired a third-party debt collector to then call. What this court said in this case is this: hey, you know that FCC 2000 ruling that gave you creditor consent or you debt collector to call on behalf of a creditor if you get that, if the creditor got the number voluntarily? Well, this court said this: I don't believe that applies to the medical debt context. I believe it only applies to a retail credit transaction. Retail credit transaction where the debt collector is collecting on behalf of the creditor in a retail credit circumstance. So he says, I don't think the FCC ruling applies to medical debt. That's number one. And he goes, and you know, he goes, let's just say I do. He said, I'll give you the benefit of the doubt and say it does apply to medical debt. Well, guess what? I think that this ruling that this FCC gave, I think that's where they give the creditor, that the debt collector has consent. If the creditor has it in the first place and they're collecting on behalf of the creditor, he goes, let's just be frank with each other. I really believe that's implied consent. That's not express consent. We're implying that the debt collector has it by virtue of the fact the creditor has it. So he says, I'm sorry. The language of the TCPA is clear. It says express consent. That is not, I'm throwing out and ignoring the 2008 ruling. He disagrees with it, and he says it's not applicable. And this court believed that they had the right to throw out this FCC 2008 consent ruling. Then he goes, well, I'm going to go a step further. Even if I say it applied here, and even if I apply this 2008 ruling to this medical debt here, the problem is here that the number was given to the hospital, but the hospital wasn't collecting a debt. It was the third-party independent contractors, I believe the radiologist. And the radiologist then took that number, then gave it to their debt collector. He goes, I don't believe that the FCC's ruling goes that far. I think where it was, this was given to the hospital was not collecting a debt, no prior express consent, even if I applied the 2008 ruling. Very, very problematic decision. Again, all of the issues that I just raised, all of those four critical issues and a couple others, they're going up on appeal to the 11th Circuit Court of Appeals. This was a Florida case, so it's going up to the 11th Circuit. 11th Circuit tends to be conservative, so we'll say if they disagree with this judge completely. The Chavez case right below, they disagree with the Mays decision completely, and they said, I think this judge went way too far. I disagree. I believe that that the 2008 ruling does apply to the collection of medical debt, but in this case, it was a medical center who was collecting its debt. The medical center got the number voluntarily, then gave it to their debt collector. So there's a more one-on-one relationship there, slightly different. But this court says something else. This Chavez says, hey, by the way, oral revocation, sorry, when someone gives their number in writing, they can't orally revoke. Well, I believe that is incorrect, and I believe if challenged on appeal, it would be ultimately reversed because the Third Circuit at least says it has, and other jurisdictions throughout the United States, the majority say someone gives you their number orally or in writing, and they tell you orally that they don't want to be called, you should honor that. The TCPA was silent. Next. Let's talk very briefly about the timing of revocation. We've already talked about the Geiger decision. Next. Oh, so wait, go back one. I just have to tell you, I thought this picture was hysterical as a picture demonstrating revocation. I did not pick it, but my brilliant law clerk did. So this looks like a woman apparently giving a pot of soup to her husband. He's pushing the pot of soup back to her and then proceeds to try to shoot her with a laser gun. How this represents revocation of consent, I don't quite know, but just work with me here. It's Halloween. Next slide. Very quickly, we already talked about the Geiger decision. Geiger says, hey, oral revocation is okay. Someone gives you consent. I don't care if it's orally or in writing, and then they revoke it orally. You got to honor that, and there's no specific time in which they need to do that. Other courts say that as well, populate. Some courts say, as you'll see in the middle slide, those courts say, hey, look, when you're revoking consent in the context of debt collection, we're going to deem that revocation as really a cease and desist. And guess what? We think the TCPA controls and trumps the TCPA. So we're saying, hey, it's a cease and desist under 1692 CC. That must be made in writing. So the debtor didn't properly revoke because he didn't do it in writing. Next, other courts disagree with that. Obviously, Gager disagrees with that. Other courts say, look, TCPA, FTCPA, two separate statutes. Someone revokes their consent orally, honor it. Next. Let's talk about one of the other motherships here, and you could populate the whole page. Automatic telephone dialing systems. What are those today? Well, it's very confusing and no one quite knows, but very quickly, let's just go with the TCPA's definition, and let's start there. Then we're going to talk about how the FCC has expanded and impacted the TCPA's definition. Next, populate the whole page. So the TCPA defined a dialer as this. It's got to be some kind of equipment which has this capacity, and that's the key word, capacity to store or produce numbers using a random or sequential number generator. Boy, that again, it's equipment, has the capacity, it can store or produce numbers using a random or sequential number generator. Well, that says something. The FCC says, and this is what the FCC did in 2003 and again in 2008. They said, oh, okay. They recognized that the telemarketing and other industries were getting smart with the TCPA. They all started taking out their random or sequential number generator programs out of their dialers so that they wouldn't constitute dialers under the TCPA. But the FCC said, you think you're so smart? Well, let us tell you what we think a dialer is under the TCPA. Number one, we think those predictive dialers industries that you're using, and including you, debt collection industry, we think your predictive dialers actually constitute a dialer under the TCPA. That's number one. And they said, you know what? When you upload a list of numbers to a dialer and you can program that dialer and it can start dialing those lists, and it can dial them without human intervention, we think if you have a dialer that has that capacity, then that is a dialer that falls under the purview as the TCPA well. So it's predictive dialers, dialers that have the capacity as well to dial numbers without human intervention. Very dangerous ruling because this so expanded the definition, as you see above, that the TCPA has. The TCPA had a very specific definition, but unfortunately, FCC thought that they believe that they have the power to expand that. But look very below. Look at the very last line here. Look what the FCC said this, and I picked this up. They said, not only in 2008, but they said this back in 1991, in their 1992 order, I believe paragraph 39. They said debt collection calls are not auto dialer calls. That's an incredible pronouncement. Again, debt collection calls are not auto dialer calls because they're not using a random or sequential number generator. But when the debt collection industry used that and said to the FCC in 2008, exempt us, if you're not going to exempt us from the TCPA, at least say that the calls that we're making via our dialers, our predictive dialers, those aren't auto dialer calls because you already said it. FCC, you already said it that they're not auto dialer calls, so just confirm that so everybody's happy and everybody's clear. They said, no, we're not going to do that, and better yet, we're going to say those predictive dialers you're using, they are dialers, and those dialers which have the capacity to dial with human intervention. The FCC said themselves, what does that mean, that capacity to dial without human intervention? What kind of dialer is that? They go, does that mean now that we're bringing into the fold iPads, computers, and your cell phones, your smartphones? Because they could certainly have the capacity to dial without human intervention once you program them. Yes, the FCC has said for years that speed dialing a number doesn't constitute a dialer under the TCPA and does not constitute an auto dial call, but hey, they're making this so broad no one knows anymore. And they're going against their own very pronouncement where they said that debt collection calls are not auto dialer calls. It's like you said it, FCC, so you're contradicting yourself once again. Once again, you're saying predictive dialer calls are problematic. Calls without human intervention via those dialers that have that capacity are dialer calls. But on the other hand, you're saying they're not auto dialer calls. So what gives here? Next. There are petitions that you know pending with the FCC and the world, not just these petitions, but the entire world, the banking industry, the healthcare industry, the debt collection industry, dialer companies, the airline industry, the cargo industry. They are saying, look, you got to give us some relief here. You got to give us clarity. Let's first start with the Communication Innovators petition below. They're saying, look, FCC, no one knows what a dialer is anymore, and please clarify whether a predictive dialer is going to fall under the TCPA, even if it has no capacity to store or generate randomly dialed numbers, which is the TCPA's definition. So just give us some clarity there. Is that type of predictive dialer still going to fall into that purview, even if it doesn't have that technology? And better yet, why don't you just go back, FCC, to the TCPA's definition? That was the definition that got Congress enacted. They haven't changed it. And let's just stick with that, right? And let's have a level playing field here. Well, we do not believe that the FCC will go that far because we believe that that may give rise to what the FCC is concerned with, unintended consequences of opening the floodgates of dialers. So we don't think they're going to back off the rulings that they have repeated in, let's see, FCC 2003-8 in their ruling. I'm sorry, in 2003 when they issued their FCC 2003 ruling, again in their FCC 2008 ruling, and what they repeated again in their FCC 2012 ruling in the soundbite petition. Let's look at PACE real quick. PACE is asking them, PACE says, oh look, we've got this, we've got your order, FCC, we get it, we get that we may be stuck with it, but at least do this. Deem that we're not using a dialer under the TCPA unless it has capacity to dial numbers without human intervention. That's number one. And by the way, FCC, if you're using the word capacity, just at least agree that that capacity is limited to what the dialer is capable of doing without modification, meaning at the time the call is placed. So I make a call with my dialer, and at that moment it has no capacity to do certain things. Let's not deem that, oh, well, you know, your dialer has theoretical capacity, and you could add some software and hardware very easily to this dialer, and therefore it may constitute a dialer. No, that's not fair. The capacity has to be deemed as what is the present capacity at the moment next that the call is being made. That's only fair here, because theoretical capacity means next everything and anything is game. So, some good next. Let's talk about some good decisions here. We do have the Satterfield decision out of the Ninth Circuit. And Satterfield said, hey, there's no reason to look at the FCC ruling, basically, because next, Congress's definition is clear and unambiguous on its face. The FCC, Congress has spoken. Congress has given a definition. It says what a dialer is. It's in the TCPA. And if Congress issues a statute that is clear and unambiguous, you stop there. You don't look for any other definition. In fact, you're not even allowed to under Supreme Court authority. It says you can't. Congress has defined something. You can, yes, look up what their words mean under a plain dictionary meaning, but you can't look to what is another person's definition of that same issue because Congress has spoken. End of story. Ninth Circuit, that's a great pronouncement by Satterfield. But then we have the Ninth Circuit coming out 3 years later, and they said, hey, we agree with Satterfield, and they never disagreed with anything they're in, but for some reason, and it's unexplained, they made this leap in this case, and they said, hey, defendant, you're using a predictive dialer? Well, guess what? The FCC said that your predictive dialers fall squarely with the FCC's definition that they gave in 2008, so sorry, you got a dialer that falls into the purview of the TCPA. That didn't make sense. There's many reasons why I think that decision doesn't mean literally what it says, but it's a very complex legal issue. I can't get into that here, but I'm making the argument in various other cases because I have countless TCPA class actions pending for numerous clients, and we're fighting this battle right now. We like the Satterfield decision because we think it makes sense. We even think it makes better sense to argue this. Okay, FCC, maybe you're allowed to consider what technologies in the future after 1991 when the TCPA was enacted potentially may fall within the purview of the TCPA, but that doesn't mean it does. So a predictive dialer could potentially fall into the purview of the TCPA, as long as it meets the TCPA statutory definition. You can't just ignore what the statute says. If we just look at what the FCC says, that a dialer, a predictive dialer is a dialer under the TCPA, then we're basically ignoring the TCPA and Congress's statute on this issue. You can't do that. You've got to look at both together. Next. And I think that's the fight, and that helps you with a level playing field. Let's talk about a really good decision. So the Hunt decision out of Alabama recently, I know all of you said it. Well, one of the things they say is, hey, when we're talking about this issue of capacity, you got to look at present capacity, not some theoretical capacity as to how a dialer could be reconfigured in the future with X amount of hours of technology updates and programs, et cetera. That doesn't make sense. So I think this is, if the FCC ever rules on this issue, we would hope that they would buy this, because only present capacity makes sense. Between this case and all of the other petitions that are before it saying, hey, look, FCC, only talk about present capacity, I think we're starting to try to break down the FCC to get them to rule on this issue. This court said another thing. This court said, look, if you're using pre-recorded messages, well, it doesn't matter if you're using a dialer or not, because this court said that leaving a pre-recorded message was not dependent necessarily on a dialer, because the statute says using an ATDS or a pre-recorded message is potential liability for making a call to a wireless line without consent. Using a dialer or a pre-recorded message. It doesn't, the TCP never said how that pre-recorded message had to be delivered. But this court also said something else. It says, hey, we're going to follow this Satterfield decision because we think the Ninth Circuit makes sense. We think that you have to have, equipment that has this capacity to, store or produce numbers from a number generator. Well, that's great, because 90% of the dialers that are out there right now, and I believe most of the dialers you are using, don't have this random or sequential number generator. They don't generate numbers. They don't store numbers using a generator. It doesn't exist. So that helps to make a level playing field if your court will, quote, buy the Satterfield argument plus the Hunt argument and ignore the Meyer argument. Next, Hunt's a good decision. This is the way we hope that these fights on these dialer issues can be made, to start breaking down this whole dialer issue, because there's numerous courts throughout the country. I got to be honest with you. Let's just say the 7th Circuit, which is Illinois, Indiana, Wisconsin. They say, sorry, the FCC says that a predictive dialer is a dialer under the TCPA, and we can't challenge FCC final rulings and final orders. A federal court of appeal can, but the lower level federal district courts, they can't challenge final FCC rulings. So they say, we're stuck with the FCC ruling. It says predictive dialers and dialers that can dial without human intervention. And if that comes out in the case, well then guess what? You got a dialer that falls into the purview of the TCPA. Well, that not all courts believe that. Not all courts are bound by the FCC's rules, but some are. And that's the problem, that they're stuck with the FCC rulings, and this can only be challenged on the federal appellate level. The Griffith case there at the bottom, that's a problematic decision, because they looked at the FCC ruling pretty strictly, and they even went so far as to say, well, gosh, if this, if the capacity, if the dialer can be easily reconfigured into a dialer that has the capacity, well, we believe that's a dialer. And the Griffith case out of Illinois rejected Satterfield. I think Griffith has a very fallacious reasoning by the court there. Nevertheless, it's a decision out there, something we have to fight. Next, let's talk about preview mode. Sorry, go back one. Preview mode dialing. I know this is problematic. Everyone says, can we preview mode dial and avoid a dialer under the TCPA? Well, it all comes down to capacity. In preview mode, this is how it traditionally works. The agent or collector is sitting at their screen. The screen is populated, and then the person has the choice to make the call via a click or a dial or a press on the keypad, and that will launch the call. The way the calls are launched by many companies is going through, quote, what is deemed a dialer, whether that dialer is considered a dialer under the TCPA or under the FCC rulings. So if you're making a call in preview mode, but that call is then, the minute it's launched, it goes through a dialer, is that a call that's made through a dialer that has the capacity to dial without human intervention, or is a predictive dialer? That's the problem here with this preview mode. It's all about the capacity, and the courts are going to look at the capacity of the dialer through which the call was made. Yes, you are using human intervention, and if you could determine that, hey, the only way this dialer could ever dial is with the human intervention, well, that's an argument that could be made to say this is not a dialer that falls into the purview of the TCPA. But if the court looks behind the man behind the sort of curtain there, so to speak, and he says, well, yeah, you made this call in preview mode, but basically you made the call and it went through a dialer that has the present capacity to act as a dialer, well then, sorry, you have a call that's made in violation of the TCPA because you used the dialer. That, as you know, was the Santander decision, which has now been vacated. That court said, look, defendant, you basically admitted that you're using a predictive dialer. Predictive dialer is what the FCC is using as a dialer. Yes, you made the call in preview mode where someone clicked it, but sorry, it still went through a dialer that has the capacity to be a dialer under the TCPA. Therefore, this preview mode doesn't work. It didn't work for that court. Could other courts find that reasoning and that logic to be true? Yes. Could other courts say that, well, you dialed in preview mode, but sorry, capacity is the key, and you used ultimately a dialer that has the capacity that the FCC said is the problematic. That's the problem here. Next. We've already talked about the capacity. Ryan, next. Let's just briefly talk about these new telemarketing rules that come into play because everybody's concerned with them. But these are, again, telemarketing rules effective October 16th. This is where the FCC is requiring prior express consent in order to make calls under the TCPA. So this is a new rule. If you're making a call, it's a telemarketing call, it's a sales call, it's an advertising call. It is not just purely informational or a purely commercial call without, and if it has a solicited advertisement or it's advertising or upselling anything, then it is likely a call that falls into the purview of the new rules. Courts, FCC says you've got to have prior express written consent, and they go so far, and I know this is horrible, that the EBR, the Established Business Relationship Exemption, which may have given you consent to call numerous calls, is gone. You don't have the EBR anymore. It's gone. And the commercial call exemption doesn't apply to a telemarketing call. So, again, the FCC, FCC is going to maintain its prior express consent for informational calls. That means you can get consent orally or in writing. You have the choice. But for telemarketing calls, sorry, it has to be written. Well, what is this and what's required? You've got to have a written agreement. It's got to have the signature of the person to be called. And in this agreement, it must clearly authorize the seller that they can deliver advertisements or telemarketing messages, and it's got to list all of the sellers for whom they will be, quote, telemarketing or selling. You even have to tell the person in the written agreement that you're going to be using automated telephone dialing systems or pre-recorded message, and the person has to give their telephone number to be called very clearly. Next. Well, how do you get this written agreement? Well, look, it's very difficult, and sellers, they've got to tell them in addition that, look, we're going to deliver you calls via automated dialing equipment and pre-recorded messages, and that the person, whoever signs this agreement, you are not required to sign this agreement directly or indirectly in order to, quote, purchase any goods, and you don't have to purchase any goods, and you don't have to sign that agreement. So that's a problem, but it's how do you go about this? Next, how do you get this? Well, the FCC has said, look, you can get this in writing. You have a written agreement that has all of these disclosures, and someone signs it. It's in some kind of mortgage application, a loan application, other kind of application, other type of agreement, some kind of sales agreement. They sign this agreement, a hard copy in writing, good to go. You can also get it via the e-Sign Act, and that lets you get it this way, via email, via a website form. You can get it in text messages. You can get it in a telephone key press and a voice recording. If you get it in a voice recording, you should also have some kind of technology that allows the person to either, quote, confirm via voicemail that they are in fact agreeing to everything that has been said and that they're voluntarily providing their information, or a telephone key press that says, yes, I confirm and I consent to this telemarketing campaign, or to sign up for this and to get these sales pitches, et cetera, et cetera. So that's what you have to do with this written consent, and I could go on for 3 hours about the new rules here, but that's for a different webinar. It is they're very complex. I know that getting this written consent is going to be very difficult for the entire industry, but unfortunately that's what the rules are requiring right now. Next. Let's talk about takeaways real quick, because I want to answer a lot of your questions, and I'm willing to go over a few minutes on this panel as well. Let's talk about what's really important here. This is the money stuff here. Again, remember that calls can be made to cell phones via auto dialers, and you could also leave pre-recorded message calls on a residential phone line. Those are the two triggers for the TCPA. Auto dial calls and pre-recorded message calls to wireless lines, and then pre-recorded message calls to landlines. But how do you distinguish them? Get cell phone technology to identify which numbers. It will even have the ported number list, and it will tell you what numbers that you are calling, so you know not to load any wireless numbers into your dialer or leave pre-recorded messages till you know that you have that consent. Ask your creditor client to confirm that they have prior express consent for you to call those numbers. And what's very important is also include as broad as possible prior express consent language in those terms and agreements that come along with the credit card, in your mortgage applications, your loan applications, such that people are giving broad consent for the numbers that you are calling or that you may call, or for which they give you prior express consent. Also, those agreements should have these arbitration clauses with class action waivers, which prevents individuals who sign these agreements from being part of or participating or bringing in their own name a class action. Very, very, very important. The FCC has said in 2008, hey, debt collectors, what's a really good thing and what's really going to help you for is that if your creditor clients are getting express consent, well, they should have this broad language that says that the debtor and the consumer is giving the right to be called on their phone or any number that they give voluntarily via an automatic telephone dialing system or pre-recorded message. Great way to capture consent. The only way, absolutely not, but a great way, because then you have evidence. You can demonstrate prior express consent with that. Next. So, again, capturing numbers via prior express consent, not a good idea, because you never know if you're capturing something, whether you do have prior express consent to call it. Don't load those numbers into your dialer. Go back. Also, I'm sorry, go forward. We've already gone over some of this. Capturing. Don't capture numbers on inbound calls. Again, if you don't know you have your consent, manually dial that call, capture the consent, document it in all your collection software, in your account information, document that someone gave it to you, code those calls so you know their calls with express consent, and have the backup for it. Remember to be very careful with regard to preview dialing. You don't know if that's going to constitute not using a dialer under the TCPA. There's arguments both ways, and plaintiffs believe that they have the better argument. We on the defense side think we have the better argument. It's going to be capacity of the equipment that the call is going through is going to be a potential issue that you must examine. Also, train collectors and all of your agents to properly capture consent, to get consent, to ask for consent, and to document it. Next. So document your consent, as we said, in your software, identify your phone fields, and remember to be able to distinguish between numbers that you have consent for, skip trace numbers, or number that you get from any other the other source. Also, talk to your IT people, your engineers, your dialer companies. Ask them, do their dialers have random and sequential number generator programs, software, and hardware in their systems? If they do, the number one thing is to do, yank that out. You want to take that out because you don't want to have a dialer that at least you want to have a fight that you can argue that your dialer doesn't constitute a dialer under the strict TCPA definition. Also very important, please examine your securities filings, your website, your responses to RFPs, your marketing materials. If you can, but consult your attorneys, please. Delete, if you are able to, references to dialers, predictive dialers, auto dialers. You use that language, that is just a trigger for plaintiffs to say, aha, you're using and you have admitted in your paperwork and in your filings and on your website that you have a dialer that falls into the purview of the TCPA. That's the last thing that you want to do. Really the last thing, because this is just a boon for plaintiffs to try to then file a TCPA class action if they get one particular plaintiff who they can use as their lead plaintiff. They're going to say, gotcha, and they're going to ask you to admit then in discovery documents that you were using such a dialer because you said it. But of course, consult your attorneys in this regard. Very important whether you can make any changes to all of these type of documentation in these electronic documents that I'm referencing. I believe that this is the end of this session. I thank you so much for all of this. I know a lot of this stuff is spooky, it's scary. The TCPA is difficult, it's problematic. I am out there fighting the fight for you every day with numerous industries trying to make change. I'm fighting with the FCC directly. I'm fighting in trying to change my clients from a compliance standpoint, and I'm fighting in litigation throughout the country. Of course, you have to remember this. We've got to choose our battles in litigation. It's got to be the right case, the right set of facts in order to make some of the arguments that we're making, and that's some of the issue too. We have time for questions. I don't see any of the questions that may have populated. Ryan, thank you so much. Tom, thank you so much for allowing me to be part of this this seminar. And Ryan, if you could maybe call out the questions because I cannot see them populated, and I could answer some questions that haven't been already answered by the presentation.
Thank you, David. That was a wonderful presentation and a really good update of really what's going on with some of the craziness out there. I know we're getting a lot of questions about the content and just in general here at our office. The phone has been quite busy. There's a lot of confusion about what you need to do with complying with the TCPA, I think, from both sides of getting consent and then how you implement scrubbing, how you deal with separating out cell phone numbers and landlines. And I think that the one thing that definitely is clear is that there is going to be more enforcement and certainly more cases. I mean, I know you guys have been busy at your office, and now that the law has changed on the 16th of October to the express written consent, that's a big impact for a lot of companies. And what we offer is the ability to do cell phone scrubbing, and there's some confusion about what that really means and how you can do it, and so we can help companies out if they're interested. My information's there. We can follow up and even do a free kind of wireless evaluation, really where we'll take a look at how many numbers that you have on file that are cell phones that are owned, that are part of being ported, part of Newstar's list, or owned by a carrier, and we can also identify what carrier they're on. So we can provide a feed so you can separate out your calling patterns and comply with the TCPA. So we can make that and integrate with a lot of solutions, including Interactive Intelligence, one of the partners that Avtex and I both work with, that enables automated scrubbing, as well as a lot of other dialer platforms, CRMs, and then we also supply the data to a lot of companies that want to do their own scrubbing. So not to get too far away from the questions, but I didn't want to interrupt David's presentation about kind of how that gets handled, but it's certainly a big part of what we do and what our conversations are with our customers. And so let's go back to some of the questions about the types of calls, what's exempt. I think a lot of people kind of want to know if calls like informational are exempt, survey calls, there's a couple questions about exemptions to the TCPA. Can you maybe explain a little bit more about what really is exempt or what's not, or healthcare-related calls, open enrollment calls, those kinds of things?
Very good question. There is no exemption for any calls under the TCPA that are delivering, let's say, informational calls and just pure information, or a commercial call. No one really has a pass or an exemption. Believe it or not, not even the U.S. government. That's been an issue that's been plaguing people right now. But if you're making calls on the telemarketing side, the healthcare industry, the airline industry, and any other industry, to the extent that you're not, quote, leaving an unsolicited advertisement and it's purely informational call, you're not subject to the new TCPA written prior express consent rules. So that's very important to know. Generally for healthcare calls, those are exempt from the new rules. The collection industry is also exempt from the new written express consent rules. So I hope that that clarifies.
What about marketing calls to business landlines with a dialer? Is that allowed?
If you're making a marketing call to business, business to business has not been excluded under the TCPA. It depends on the circumstance of this call, and I'd have to know more facts, but there's not an exemption just because you're making a business-to-business call if the call is to a cell phone.
And a lot of companies use their cell phone as their primary point of contact, contractors, realtors, tons of companies, so that would answer that question. Let me go down the list here. We had quite a few. I'm trying to make it.
And I don't, I can barely see them, Ryan. Unfortunately, it's not popular. I can see them, but it's in such a tiny screen I can't even review it.
Let's talk a little bit about the TCPA and changes in regards to text messages. The question is, how does the new law apply to text messages? Am I allowed to make a one-to-one text to a customer who I have an EBR with? I'm an auto dealer contacting customers who have requested info about a car.
Well, if someone's calling you or they're contacting you via text message and they're calling about a car that sounds like upselling or potential sales, and the Ninth Circuit has recently ruled that if it sounds like sales, looks like sales, it is sales, and it is telemarketing, and a text message would be considered a call under the TCPA because the Ninth Circuit has ruled on that issue as well. A text message, even for debt collection purposes or telemarketing purposes, is a call that potentially falls under the TCPA. So a text message, you would have to have prior written consent if you are upselling or selling.
Somebody gives you consent for text calling. Does that mean that you're allowed to then use them, then call them with an automated dialer?
If someone is calling via an automated dialer, and or rather, if someone says yes, you may go ahead and text me, then you have permission to text as long as you have prior express consent to do that. But the minute the person says stop, or they text you stop, and they tell you not to call them or to text them anymore, then you need to honor that.
And you have to honor that across texting or calling. Like if they opt out text-wise, that means that calling is no longer allowed as well, right?
Right. If someone says, don't ever contact me by any means, then I would honor that. That means don't call me, don't text me, don't do anything. If they've given you permission to text and they said, don't call me on my cell phone, that could be broadly as construed as don't text me as well, because unfortunately a text is a call under the TCPA, at least according to various jurisdictions.
Makes sense. This is the same kind of opt-out question. Or actually, this is an opt-in question, and it is, if an individual calls my call center, can I route them through an IVR that asks, with the correct wording, for permission to call them back? Press 1 to provide permission. Is that considered express written consent?
So someone calls you, okay, so we're having a telemarketing question now. Someone calls in, and they're asking if someone calls in, they're calling in, and then you want to capture prior written express consent. If they called you in the first place, they're calling you, you're not calling them. That's number one. And then you can go through the protocol to try to capture their consent with an opt-in and a key press. Yes, that should work if done correctly. I'd have to know a little more details, but it sounds like you could potentially capture written express consent under the e-sign Act in that regard. I have a question here. Unless, Ryan, you have one, I can barely read it. But someone is asking if we have prior express consent, do we have to offer an opt-out option when broadcasting a pre-recorded auto-dialed call? If you have consent and you're making a broadcast in your pre-recorded auto-dialed call, when we're talking about non-telemarketing, let's say it's a commercial call or an informational call. If someone gives you prior express consent, then you could technically send them pre-recorded messages in a message blast type fashion. In other words, you could deliver the call to their wireless line via a pre-recorded message, and you already have prior express consent. Ryan, you see any more questions? I can't.
Yeah, this one is good because I get this one all the time, which is kind of the question of how often should I scrub my phone list for either cell phone and or DNC, and especially with reassignment of phone numbers, porting of cell phone numbers, what's required, and what do people recommend? And so, if you look at, go ahead.
I'm sorry, that's a fantastic question, Ryan. So the question is, how often should I be scrubbing? Listen, with the change of numbers today, with numbers that are being ported from, and when I mean ported, I mean it was once a residential line, but it's being ported now to a wireless line. That's what porting truly is. And porting is not call forwarding. So because people are doing that on a daily basis, and I believe most of the cell phone identification companies offer cell phone identification technology that's updated almost on a daily basis, I would run all the numbers on a daily basis. If you can do that and it's cost efficient and you're able to do it technologically, then it's better for you. You're going to be helping to protect yourself and identifying those numbers that you potentially don't have prior express consent to recall.
Right. I mean, I usually tell people the minimum is every 15 days, but if you want to get all the updates and avoid people that have just changed their number and could generate potential complaints, then doing it daily or real time is really a better way to do it, especially with the ported issue. And that creates a lot of conflict about what you do with previous inventory, data that sits on a dialer. There's a lot of different ways that you can work to keep that updated that I'm happy to talk to people offline about, but that is a good recommendation. Does that help when you go to fight these cases? If a company's done a good job scrubbing, it can provide a lot of documentation. Do you bring that into your litigation strategy?
That's a great question, Ryan. I think the better documentation you have, the better you have internal systems, and that's why compliance is so important. I work with my clients all the time in developing compliance protocols for TCPA compliance to help mitigate the risks of TCPA just individual and then class action litigation as well. So if you have, the business protocols that are necessary that you should have in place to help you to show that you have a business compliance product in-house to comply with the TCPA, well then you can help yourselves to potentially mitigate the risk of TCPA class action litigation, and you have something to defend against these cases. That's what's so critical. Next question. Someone asked, is there a reasonableness standard regarding how often to scrub? There isn't. Remember, the TCPA by most jurisdictions is considered to be a strict liability statute. What that means is that you violate the law, you violate the law. There's no good faith defense built in, unfortunately. What courts have said is that the good faith of the company and trying to do the right thing, that comes into play when the company or the court is trying to distinguish between whether a call should be at the negligent violation on the lower end or a willful violation under the damages prong of the statute. But you don't even want to get there in the first place. If you're already there at that point, you have a potential problem. So there's no good faith defense, like saying, well, I was trying to scrub, but it just didn't work. Unfortunately, it's a strict liability statute that goes to the whether you were acting in good faith for willfulness purposes, as most courts would construe. There is really no regulation or case law under the scrub issue, and but the FCC did say, by the way, in the 2003 ruling, they said, hey, look, we're expecting you, debt collection industry, to be scrubbing your cell phones, as is the telemarketing and other industries, because the technology is out there. There are cell phone identification programs, so you should be getting them and using them, et cetera, et cetera, et cetera.
In the identification, I mean, there's only one source for the ported numbers. A lot of people are asking about, well, where do I get the ported numbers? What about the numbers that used to be landline that are now cell phones, or vice versa? Basically, the FCC set up a kind of sweetheart deal with Newstar when they were asked about where do we get this database from a large call center back when they created the TCPA. And then so the FCC basically set up an escrow company holding deal with Newstar, and that's really the main source, or the only source, to get those ported numbers. There's about 6 million people that have taken their landline, making it a cell phone, and about 500,000 that have gone the other direction, meaning they took their cell phone and made it their landline. So basically there's about 6 million out of 300 some odd million, about almost 2%, that have people that are ported that are falling into that bucket. And so you have to check on that, and then the area codes and exchanges. And there's multiple providers including ourselves, for pulling that file in and doing that level of scrubbing. But the question to ask your vendor, however you're doing it now, is do you use the first 6 digits or the first 7 digits? The first 6 is not as accurate, obviously. So that's why a lot of companies use us for the wireless ID and to flag their records in their database, all that stuff David's talking about, because we can provide that at level of accuracy on a scrub. So it is not a hard thing to do, but it's hard to track. If you have to create the records in the database and maintain how long you've been scrubbing for, you need to do that over a long period of time. Otherwise, you don't have a whole lot of ground to stand on.
Another thing about scrubbing, there is, if you call a residential line that has been ported to a wireless line, under the FCC rules, you likely have a 15-day exception. In other words, if someone ported their number from a landline to a cell phone on January 1st, you can still call that landline via automated dialing technology that falls into the TCPA for 15 days. But once that 15 days is up, there is technology out there that can tell you that that number has been ported and that it is in fact a wireless line. So that's why scrubbing often, every couple of days or every day if you can, is a good thing to do, because numbers change so frequently.
David, I think we're kind of running out of time here, and I know a lot of people are getting ready for their Halloween festivities a little early, and I know people in Boston are probably pretty happy now that the Red Sox pulled off their big win. I stopped paying attention to baseball a while ago when the A's fell out, but I think what we're going to do now is kind of close down the call and answer any other kind of longer offline questions as best we can. We do have another event coming up in Miami on the 14th with some more information about TCPA compliance, more telemarketing focused, and we'll probably do another webinar as these rules evolve, as these petitions that PACE and some of the other entities have filed make any headway. But and then we'll post those, and we'll get the slides and the recording link that'll be available on our YouTube channel within the next day or so people can catch up on information. I know, but David, you had a lot of material, and I appreciate
thank
you
all
spending
so
time
much.
with us.
If anyone needs to contact me, you have my contact information on the materials, and a pleasure working with all of you, Ryan, Tom, and thank you, Avtex. Thank you, Contact Center. Greatly appreciated.
Thanks, everyone. Happy Halloween.
Happy Halloween. Thanks, David and Ryan. Talk to you soon.
Thanks.